How to create an estate plan in Texas, a step-by-step guide. Creating an estate plan may sound complicated, but it doesn't have to be. In this video, I'm going to walk you through exactly what goes into an estate plan, the step-by-step process to create one, and how to make sure it actually works when your family needs it the most. Hi, I'm attorney Aaron Miller, and about 15 years ago, I saw how tough it is for families when they lose control of their assets. So I decided to dedicate my career to helping people plan and protect their future. If you'd like to speak with a trusted attorney, give us a call at 214-292-4225 for a consultation. So what exactly goes into an estate plan? Let's start with the basics. What documents does every estate plan need? For most families, a solid estate plan includes several key documents to protect your assets, your health, and your loved ones. First, your last will and testament, which outlines how your assets will be distributed. If you have a trust, this is often a pour over will that ensures any assets not already in the trust are added to it. Next, there's a financial power of attorney, which gives someone you trust the authority to handle your finances if you can't. Without it, your family may need court approval just to pay bills or access accounts. Then, a medical power of attorney. This appoints someone to make healthcare decisions if you're unable to. You should also include a HIPAA release so your medical agents can access the information they need to carry out those decisions. And a living will, often called the directed to physician here in Texas. This says whether you want to stay on life support if you are in a hospital, unable to communicate, and doctors don't think your situation will get any better. Now, if you have minor children, a declaration of guardian for minors names who you want to care for them if something happens to you. For adults, a declaration of guardian lets you designate someone to manage your affairs if you become incapacitated. Finally, an appointment for agent for disposition of remains allows you to specify who handles your funeral or burial arrangements and avoids fights later on. And while not required for every family, many people also include a trust, which can help your assets pass directly to beneficiaries, avoid probate, and keep your affairs private. It may seem like a lot, but an experienced estate planning attorney can guide you through each step and make sure all the pieces work together, protect your family, your wishes, and your legacy. So how do you actually create a plan? Let me give you a simple roadmap you can follow. First, take inventory of everything you own. Start by making a list of all your assets, and I mean everything: your home, your vehicles, your bank accounts, retirement accounts, life insurance policies, and even valuable personal items like jewelry or collectibles. Don't forget digital assets like online accounts or cryptocurrency. The more detailed your list, the easier the planning process will be. Next step, document your debts. Just like you listed your assets, you need to list your liabilities. Write down your mortgages, car loans, credit card balances, student loans, anything that you owe. Include account numbers and contact information for your creditors. This helps your executor understand the full financial picture and ensures debts are handled properly. Third, decide who gets what. This is where you identify your beneficiaries or the people or organizations who will inherit your assets. You might leave your house to your spouse, set up accounts for your children's education, or donate to a favorite charity. Take your time with this step. Think about who you want to benefit from your legacy and how you want to support them. Fourth, talk to your financial team. Or if you don't have one, your attorney can help you get connected with trusted professionals. These professionals can help you review your accounts, consolidate things if needed, and identify opportunities to maximize what you're leaving behind. They can also help you understand tax implications and suggest strategies to protect more of your wealth. Then the next step, clarify your goals. What do you really want your estate plan to accomplish? Maybe you want to make sure your kids are taken care of no matter what. Maybe you want to avoid family conflict after you've gone. Maybe you want to leave a legacy to a cause that you care about. Whatever your goals are, write them down. This will guide every decision you make moving forward. Sixth, choose your key people. In estate planning, we call these people fiduciaries, or the individuals who will manage your affairs or care for your loved ones if you can't. You'll need to name a guardian for your minor children, someone to serve as your executor, someone to act as your financial power of attorney, and someone to make healthcare decisions for you. Choose people you trust completely, people who share your values and will honor your wishes. Seventh, work with an attorney to make it official. This is the most important step. While you can handle some early planning on your own, when it comes to drafting legal documents, you need a professional. An estate planning attorney will ensure everything is done correctly, that your legal documents are legally enforceable, and that there are no gaps or mistakes that can cause problems later on. They can also help you think through difficult decisions if you feel stuck or overwhelmed, so that you don't get paralyzed and you don't end up putting off your planning. Plus, they'll help you understand how all the pieces fit together and answer any questions that you have. And lastly, execute your plan. Once your documents are drafted, it's time to sign them, fund any trusts you've created, transfer assets, and update beneficiary designations on accounts like life insurance and retirement plans. This is the step where your plan becomes real and enforceable. Your attorney will guide you through this process to make sure nothing is missing. And just like that, you have a complete estate plan. It might take a few weeks from start to finish, but the peace of mind it brings is worth every minute. But here's something a lot of people don't realize. Creating an estate plan isn't a one and done thing. Life changes and your plan needs to change with it. Keep your plan current as life changes. Let's say you get married. Your new spouse should probably be included in your plan, right? Or maybe you get divorced. You definitely don't want your ex-spouse still listed as a beneficiary. If you have a new child, you want to update guardianship provisions and make sure that they're provided for. If you move to a different state, the laws might be different and your plan may need adjustments. But even if nothing major happens, your financial situation can shift. You might buy a new home, start a new business, receive an inheritance, or retire. All of these things can impact how your estate should be structured. As a general rule, you should review your estate plan every 3 to 5 years, even if nothing has changed. And anytime you experience a major life event, marriage, divorce, birth, death, relocation, or a significant financial change, schedule a meeting with your attorney to update your documents. Now you might be thinking, do I really need an attorney for all this? Can't I just create my own estate plan online? Here's why DIY estate planning usually backfires. I know online estate planning tools are tempting. They're cheap, they're fast, and they promise to make everything easy. But here's the truth. Estate planning isn't a one-size-fits-all, and those generic templates can't account for your unique situation. I've reviewed countless DIY wills and trusts over the years, and it is very rare that I see one without any problems. Sometimes it's a missing signature or witnesses, sometimes assets aren't titled correctly, sometimes the language is vague or contradictory, which can lead to disputes after you're gone. An estate planning attorney does more than just fill out forms. They ask the right questions, identify potential issues you might not have considered, and customize your plan to fit your family's needs. They also make sure everything is executed properly so your plan actually works when it's needed. Yes, a $99 online template is cheaper, but when you consider the thousands of dollars your family could lose to probate, legal fees, and disputes, not to mention the emotional toll, working with a trusted attorney is worth it. If you're ready to stop putting it off and finally create a plan that works, give us a call today at 214-292-4225 for a consultation. We'll sit down, talk about your goals, and build a plan that gives you confidence and peace of mind. If you found this video helpful, don't forget to like and subscribe. We've got more answers coming your way. Click the next video right here to stay informed.